Welcome back, legal enthusiasts. Today, we have an exciting topic to discuss that holds immense importance in the realm of appellate litigation, the writ of certiorari. In this video, we will unravel the mysteries surrounding this legal concept and explore its significance in the pursuit of justice. So, without further ado, let's dive right in. Certiorari is a Latin word. It means to be informed of. The origins of a writ of certiorari come from British legal history. A writ of certiorari is the Supreme Court's acceptance of a petition filed with the court, asking for a review of a lower court ruling. The writ of certiorari, often abbreviated as cert, is a powerful legal tool that allows a higher court, usually an appellate court, to review the decisions of a lower court. It's a crucial mechanism for ensuring consistency in legal interpretations and safeguarding the principles of fairness and justice. While the writ of certiorari is applicable in various jurisdictions, we will focus primarily on its usage in the context of the United States Supreme Court. This court, being the highest judicial authority in the land, possesses the discretionary power to grant or deny a writ, depending on the merits of the case. If the appellate court does not want to take the case, it will deny the petition. This is usually acknowledged as cert. Denied, if the case is accepted, then a writ of certiorari will be issued to the lower court, and a court hearing day will be scheduled. Certiorari review is always discretionary. The court denies most petitions, and thus leaves the decision of the lower court to stand without review. However, a denial of certiorari does not mean the Supreme Court implicit approval of the lower court ruling. On average, only about 70 cases will be heard annually. This is less than 5% of all the petitions filed with the Supreme Court each year. How does the process work? 1. Filing a petition. The party seeking the review, known as the petitioner, files a petition, formally requesting the Supreme Court to grant a writ of certiorari. This petition outlines the legal issues involved and presents arguments for why the court should hear the case. 2. You must file your petition for a writ of certiorari within 90 days from the date of the entry of the final judgment in the United States Court of Appeals or highest state appellate court, or 90 days from the denial of a timely filed petition for rehearing. In state court, the filing date can be 30 days. 3. Solicitor General's role. In many cases, the U.S. Solicitor General weighs in by filing a brief expressing the government's opinion on whether the Supreme Court should grant the writ. This can influence the court's decision on whether to take up the case. 4. Grant or denial. The Supreme Court justices review the petition and decide whether to grant the writ of certiorari. If granted, it means the court has agreed to hear the case. If denied, the decision of the lower court stands. Remember, it needs 4 justices to agree to accept the case for a hearing. This is called the Rule of 4. In modern practice, the court will almost never create a document that is a writ of certiorari. Instead, Supreme Court Rule 16 tells us that after the court considers the petition stage documents, it simply enters an appropriate order. If the court grants the petition for writ of certiorari, the clerk will prepare, sign, and enter an order to that effect, and will notify forthwith counsel of record and the court, whose judgment is to be reviewed. Further, the clerk will request the clerk of the court having possession of the record to certify and transmit it. A formal writ will not issue unless specially directed, states Rule 16. In conclusion, the writ of certiorari holds immense significance in the legal landscape. It provides a means for higher courts to review lower court decisions, establish legal precedents, and safeguard the principles of justice. So, the next time you hear the term cert, you will have a better understanding of its importance. Thank you for joining us today as we explored the intricacies of the writ of certiorari. We hope this video has shed some light on this fundamental aspect of appellate litigation. Remember to subscribe to our channel for more insightful legal content. And as always, stay curious, stay informed. Until next time.